Hello and welcome everybody to today's webinar, Post-Pandemic, Kabhi Khushi, Kabhi Gham. My name is Rupa Laka and I'm construction partner at Charles Russell Speechlys in London. Now, in terms of introducing today's webinar, you don't need me to tell you that the last year and a half has been very challenging. And there is a challenge that is yet to come. From the perspective of the construction industry, we've all lived it, we are living it. But even before the pandemic, the construction industry is one that we aligned with the title of today's webinar, Kabhi Khushi, Kabhi Gham, an industry with highs, with lows, with great success, energy and innovation, and yet with some common pitfalls. Now, the pandemic has highlighted the Khushi. We've seen more collaboration in some respects, but it's also brought the Gham to the forefront as many businesses have suffered in construction and beyond. We look today in this webinar to considering what some of those common pitfalls are and how we can better react to them. Although the challenges may be similar for the UK construction industry and also India, the impact and approaches to resolution could differ in the two jurisdictions, and there may be some lessons to be learned. The question today, therefore, is whether at this juncture, as life seeks to return to normal, or the new normal, what will that be? Are we about to descend into lengthy disputes over extensions of times and variations, or will we see a more collaborative approach? If it is the latter that we want to see, how can we actually get there? What steps can we take to make it happen? I have an absolutely fantastic panel to discuss these issues today. Turning to my panel, Martin Harmon, Mr. Sharma, Sharad Anand from Link Legal, and David Goodman from BlackRock. This webinar has an Indian focus. India is the world's third biggest economy, and it's soon set to be the second. It's also the second biggest foreign investor into the UK. Now, whilst India's position as a global superpower is undeniable, we've got to consider the relationship between India and the UK. With the recent announcement of the Enhanced Trade Partnership and the commitment to opening up the legal sector, there's going to be greater opportunity for collaboration, investment, trade, just to name a few things. There is lots to look out for. And now, there's lots to get through. Before we start asking questions of the panel, I'm going to launch the first poll question for today. This is where we ask you to participate in the webinar. Now, we'd just like to know, if we launch the first poll question, what part of the supply chain do you represent? The developer, the main contractor, subcontractor, consultant, or other? If I could invite you to make your choices now, please. Okay, that's good. No subcontractors I can see, but a good spread across the board otherwise. Okay, so moving now to my panel. I've outlined some of the observations and some of the challenges. Mr. Sharma, if I can come to you first. India's had a very tough time, and this year with the second wave brought some more unexpected challenges. If we look ahead to recovery, in your opinion, what do you think the roadmap out of the pandemic looks like for the construction industry in India in the short to medium term, please?
Thank you, Rupa. If we look at what happened in the first wave, well, it was compared to the second one, it was very little. The second one has been much more, problematic in the sense that virtually every family has been affected in some form or the other. People have lost friends, relatives, dear ones. And virtually every family have had a case or two of COVID. So considering all this, I think the road is a little bumpy. I'm sure it's going to be a little bumpy for the midterm, until the midterm, maybe short term surely, but until the midterm, it's going to be a little bumpy. Of course, the first challenge which we need to handle from the industry perspective is the completion of the existing projects. without LDs within the time extended. Because if you know that the government had in the beginning, at the time of the first lockdown, extended times in public projects. And then, of course, the key problem is going to be maintaining cash flows and protective claims vis-a-vis downstream subcontractors. Submitting new bids is going to be a challenge, mainly because contractors would not be having cash flows to justify issuance of more bonds because the non-fund based limits in the banking system. Well, there's a lot of money out there, but the problem is that the banks are insisting on a very high level of margins so far as non-fund based limits are concerned. Well, the key, of course, is going to be the deft and very skillful programming, because that is where ultimately, of course, that holds good even in the normal circumstances. But I think in this situation, it is going to be still more relevant to ensure that we program. And I think the key, again, when we talk of programming, is managing the contracts. And if you can manage your contracts well, I'm sure that you can be more collaborative rather than confrontational with each other, because all the stakeholders today realize one fundamental fact, that there is something which is beyond everyone's control. So I think cooperation and collaboration is going to be the order of the day. One more factor which will come in this, because the first wave led to a lot of movement of the migratory labor, and I suspect that people are now focusing on local resources and trying to avoid the situation of the first wave. Well, the second wave, one thing which has happened is that in the second wave we haven't seen such migration of labor. So hopefully that thing should settle down. So all in all, it's a bit of a bumpy road, and let's hope that the industry can, get out of this as soon as it can. But hopefully, maybe at the year end or maybe middle of next year, things should become better.
Well, I hope that your forecast in terms of timing is accurate. But you pick up on some key themes there in terms of cash flow, programming, management of resources, collaboration. We're going to pick up on those themes, I think, throughout this webinar. But those issues, they are common to the industry even prior to the pandemic, and almost they apply globally, I think, when it comes to construction. And there have been inevitable difficulties sometimes in terms of delivering projects both on time and on budget. I'm going to come and talk to Sharad in a moment. In your opinion, do you think that the procurement regime in India and the way in which contracts are procured, do you think, setting aside the pandemic, that the way that setup is there, that you've seen in your experience, does it facilitate projects to be delivered on time and on budget? Sharad, if I could ask you, I think you may be on mute.
Sorry, I was on mute, Rupa, thanks. Well, for the purpose of this discussion, let me restrict my comments to the public procurement, since that's where the major procurement takes place. And as we all know that there are some issues in public procurement, the Ministry of Statistics and Program Implementation monitor a whole lot of projects, I think in excess of 1,600 projects quite regularly. And as per the latest annual report 2021, they say that almost a third of the projects that they're monitoring have a time overrun. Almost a quarter of them have cost overrun. Time overrun is an average of about 44 months, and the cost overrun is in excess of, I think, 60%. Almost, more than half of them actually could not even report a completion time, a commissioning date. So that's the extent of the problem. And of course, the problems that they've listed are many. Most of them, of course, like Atul mentioned, they deal with program implementation, but that's what they're supposed to monitor. But if you look closely enough, I think there are a lot of issues that have a different perspective as well, and that concerns the procurement methodology and the risk sharing framework. That happens to be right now highly skewed because most of the public procurement that's taking place is taking place using the LCM, the lowest cost method, the L1 bidder, wins all type of thing. And that's, I think, a part of the problem. But if you see over the risk spectrum, if one end, if you see the LCM, the lowest cost method, which is more of a transactional method, equates to, for example, the FIDIC Red Book, which is a pure construction contract. But when you come to more complex projects like design build projects, you have to move up the value chain to more collaborative or relational projects, which are performance based, which take care of the quality of works, etc. And further, of course, if you move further up the value chain, you come to the PPP sort of projects, which deal with investment related risks, etc. For which the FIDIC EPC Silver Book type of contracts would be more appropriate. So basically on a risk sharing framework, I think the big problem is, and it's a front end problem, it's a procurement strategy problem where you have to decide where in this risk spectrum the contractor is, or the risks of the project are, and you have to then allocate those risks equitably to all parties, looking into the risk sharing capability so that the party that has the capability of dealing with a particular risk is allocated that risk. So I feel it's more of a front-end problem. There is, of course, a program implementation problem as well, but the basic problem happens to be that of the procurement methodology and risk sharing framework also.
Thank you. Well, I'm going to come on to talk about actually the way in which that risk is managed and how we should be negotiating contracts going forward. But given some of the metrics that you quoted in terms of project overrun and cost overrun, there's some scary statistics there. Given what you've just touched on, Martin, how do you think that aligns with, in your experience, international standards and what you may have seen from an international perspective if we were doing a compare and contrast?
Thanks, Rupert. I think what Sharad has said is not uncommon internationally. I think perhaps we're moving a little bit further towards the slightly more collaborative end of the spectrum. I think that's being done because governments realize that what they thought was an infrastructure boom is becoming a profitless infrastructure boom. I mean, you've got places like Australia and others where, we're seeing projects not delivering on time, so the public is losing its investment in the infrastructure, is not there on time, it's costing a lot more money, and contractors are going insolvent for various reasons, some of which Sharad has mentioned: the lowest cost method, the very limited tender period, the lack of focus on the whole life of a project, the adversarial us versus them attitude from the outset, punishment rather than incentives, all of these things, and also the excessively burdensome contractual procedures, which non-compliance of which leads to legitimate claims sometimes being artificially extinguished. And I think international governments and key stakeholders are increasingly willing to compromise on inappropriate risk allocation. They are embracing a more collaborative approach. They're rewarding innovation. They're working with experienced contractors, consultants, advisors, and helping to facilitate the effective delivery of a project. You've got relational contracting in Hong Kong. You've got collaborative contracting in the UK, Australia, Singapore, South Africa, and projects are actually improving as a consequence. We have a long way to go, but governments everywhere have to take the lead in this.
Thank you. That's some wise words there. David, given what Mr. Sharma said about sort of programming and looking at that, having that thought, we're only sort of 15 minutes into the webinar, but the stress on proper planning and risk allocation at the outset of the project, I think is key in terms of overall success of the project. In your experience, do you think that contractors recognise the importance of proper planning and coordination at that pre-contract stage in order to try and maximise the chances of having an effective and efficient implementation of a construction project?
Thanks, Rupa. Yeah, I think as the speakers have been saying, to me, planning is the key. That I've been involved in the kind of dispute programming planning end of the business for the last 20 years. And I can't emphasize enough how important planning and programming is. And without sounding cheesy, there's a quote that just says, "By failing to prepare, you're preparing for failure." And that really is it. It's the plan, is the roadmap. It's the key to a successful project. And it's the key for the employer and the contractor. And for the contractor, they've really got to go into the project with their eyes wide open. What's this project all about? And as I said, I see things from the dispute end of the business, but it's amazing how many times you trace it back to a complete misunderstanding or misalignment between the parties at the very beginning, and the contractor not really understanding, and sometimes through no fault of their own, not really understanding what the scope is about, who the key stakeholders are, what the key milestones are. And it's that really early investment in planning and programming that's really going to set you on the right path to a successful project. And that, I think, is becoming a more sophisticated way forward, but it still has a long way to go. And unfortunately, I do see, again, as I said, from my end of the spectrum, the planning is not taken seriously on day one. And I've honestly seen contractors use programs from other projects and try and quickly adjust them and put them in for their tender for new projects. I've seen employers not really explaining what they actually want, and it all just adds to a starting point of misunderstanding, and the parties then unfortunately head off in different directions from that point onwards.
Yeah, I mean, the difficulty is that at that time everybody is under pressure to try to get on with things, and
Yeah.
we've all been there, and we understand the practical pressures that apply. I think, by the way, I wanted to say I really like that quotation. I think we should use it as the title of our next webinar. I've made a note.
Right.
Thank you for that. Just picking up then into Sharon, Martin, and David, we've all talked about then, in your opinions, the management of the risk profile, that programming, that planning, the collaboration. Mr. Sharma, could I ask you, because I'm sure you will have seen it, you will have seen the impact of not doing that. Can you just give us a practical example in your experience that you've come across on a particular project where some of those things have not happened and what the consequence of that was? So, what were the problems faced?
Yeah, I think, Rupa, of course, David talked about programming once the contract is awarded. Well, I think planning is a process which should come, in fact, even during the conceptualization stage. And that is when, and particularly in the PPP regime, the detailed project report is where the whole problem comes in, and you don't identify, and I'll be repeating again and again what Sharad and Martin has said about the risk allocation. And of course, if inherently in the project, if the risk allocation is not fair, it is a recipe for disaster. The second aspect is that most of the governments don't realize that you can't put apples and oranges in the same box. And what happens is that you're trying to bring in conditions of a contract which is relevant for a project or a particular kind of infrastructure or a building into the other one. In India, that has been the typical problem, because what we have been following is in the PPP regime, because PPP will obviously involve both elements, the construction as well as development. And what we have been trying to do is trying to copy the model concession agreement in the road sector as the base. Well, obviously, it is a port project is substantially different from a road project or a metro project. Now, we had this very strange situation in one of the big metro projects where even now, when entire project is up and about, except for one segment, the alignment is still not clear because the government didn't know how to handle the land situation. And today, it has given rise to such a huge dispute that the operator doesn't know what to do with it, the government doesn't know what to do with it, but because they never planned to ensure that the land is available upfront. So in this metro project, I mean, everything is in a mess, and neither the developer nor the government want to lock horns for obvious reasons because it's a public project. But then nobody knows how to deal with the situation. So these are the kinds of situations which you need to plan, even at the DPR stage or at the planning stage. The planning doesn't start merely because a contract has been awarded and somebody has to execute it. How the project itself is conceived and how it is planned is the key to really make a success out of it. And that's where, and collaboration should start not only post, it should start pre, because all stakeholder considerations are to be taken into account at the time of conceptualization of the project, rather than conceptualizing the project and then allocating risks to the parties who are not equipped to deal with them. So that's where I think the fundamental problem lies. But of course, I mean, in India, the establishment is learning the hard way. We find there is a movement. And then, of course, on the construction side, the biggest problem is that we try to be not standardized contracts. We pick up FIDIC, Silver Book, and try to do some violence to it. And we have, we don't know really. So applying the same conditions to every contract is also not an answer. But of course, there has to be an element of certainty so far as the contracting community is concerned.
Okay, thank you. And thinking then about that detail of the project at the outset and the interface, if you like, and really working through what methodology will be required, the practical implications. Martin, that picks up on the issues, and certainly I've seen it in my experience, where you don't have that proper coordination and you haven't thought through the way in which different parties should interface with each other. Can you tell me or give me an example of your experience where that interface hasn't been properly managed and that's impacted the way in which parties then react and administer the contract, which has then led to problems?
Yeah. Certainly, Rupert. I think, going back to what everybody else has been saying, I mean, the adversarial, the us versus them approach does not allow those interfaces to work properly, because that approach, that us versus them, creates mistrust. It creates a reluctance to cooperate. And therefore, what we're aiming for will not be achieved with the current construction processes which we have, which is this us versus them. And we all know that delivering major infrastructure projects is filled with uncertainty and risks. There's changing conditions, changing circumstances, changing scope, third parties involvement, inherent uncertainties in the whole process of construction. And for that to work properly, there needs to be an understanding as to who is going to own some of those interfaces, some of those risks, and deal with some of those uncertainties. And that has to take place right from the outset, as Atul has said. What I've been doing over the years is trying to get more involved with the contractor, the early contractor involvement, where the contractor comes on to the project, that tender periods are not short, that they have a particularly decent length of time. The early contractor involvement creates a team ethos. It creates a team structure which will help with things like buildability, methodologies, compliance. All those risks which suddenly come up and bite you on the bottom when you're not expecting them will actually have been dealt with at that early stage. You work together at the planning stage. We clearly define roles, so interfaces are identified, understood, and crystallized right at the outset, uncertainties removed, and then the risk is identified and shared, obviously, as Sharon said, with those best able to manage it. Innovation is incentivized. There's a gain share, pain share, and we look at, therefore, at solutions rather than blame. And that is where I think we need to be moving towards. So that does require this early, well, not require, I think early contractor involvement will assist that enormously. Couple that with proper contractual documentation drafted by people that understand the risks and the need to manage that interface, and to have someone who owns particular areas, who know what their position, what their responsibilities are, and work together as a team, not two different silos, us versus them, right from day one.
I wholeheartedly agree with you. The challenges in practice there were that, so Mr. Sharma said cash is king, we know that. Sharad has mentioned budget overruns, time overruns on projects. So, you know, the difficulty in trying to break the cycle is that parties are chasing the tail end of those difficulties on historic projects, which pushes then a pressure in terms of getting that early investment up front, and, you know, trying to put the investment of time and resource at the outset of the project before you've necessarily secured commitment to the project. And that I think is the practical difficulty. And until we get there, there's not going to be that real shift that I'm hearing from all of you. David, you've given your perspective from the tail end of the project, but the other speakers have, you know, and actually you touched on it as well, about that early investment. From your perspective, as somebody who usually gets involved at the later stage, what do you think is the investment that is required up front, and potentially investment of your role at that time?
A couple of points on that. I've been involved in projects, and I think, you know, when we're talking multi-million infrastructure projects, you know, huge, very expensive projects that have very expensive overruns, you know, you don't have to be too late to run up a significant cost in overrun. I've been involved in, and I'm a believer in investment in the tender period. So, and it's not undertaken very often, but I was involved in a major infrastructure project where all three companies that were tendering for the project were paid by the government body to invest in the tender. So we were a tender team, we were being paid for by the client, and I think we spent 3 to 4 months really programming out this project and really taking it seriously, because we didn't have this, as we spoke about, this kind of element of let's do it quickly, let's do it cheaply, because we don't want to invest our own money in this in case we don't win. And I think that had massive benefits. And by the time the job was actually awarded, the contractor who was successful had already really thought through how the project was going to be built, you know, where the pinch points were, and really took it to the next level, rather than, as I said before, a contractor very quickly putting a program together with little thought, and also the employer. So both parties get the benefit from that. And I know we spoke about the kind of lowest cost method that sometimes contracts are awarded on, and you know, I see what I call the quickest time method, where, you know, there's a 3-year contract and there's a contractor who puts a program on the table for 2 years, and all of a sudden the employer says, oh, here's someone who says they can do it in 2 years. And that always has alarm bells as well, that, you know, can you really do that project in 2 years? And I just want to touch on one point before you move on, that I'm working on a dispute at the moment, and it's a multi-million-pound project. And the contractor who was awarded the contract had never worked in that specialist field before, and you start to think, well, who's to blame for that? It's not going well, obviously, and who's to blame for that? Is the contractor to blame, or is the employer to blame? In reality, to a certain extent, they're both to blame. And this would have all been resolved, you know, pre-contract, if we could really take that seriously and invest in it.
Well, somebody once said to me that, you know, people who are successful will think and do. People who are highly successful will think, do. And I think it's just reinforcing the point that we're all making. It's that early investment. It's not rushing in. It's really thinking ahead at how things are going to play out. I mean, that is a big commitment in terms of what we're all asking for the industry to respond to. Mr. Sharma, from the Indian perspective, who do you think should lead the way and be the example in the supply chain as to investing and giving that commitment?
If you today you see what has happened is that because the development projects have failed in India in terms of viability, the government has moved substantially towards the EPC model. And therefore, the leader has to be the government. And again, I go back to the same point as Sharad and David said about the LCM method of awarding contracts. Now, if somebody does a real empirical analysis, we will realize that the actual cost of L1 with the claims which were adjudicated in an arbitration is probably 3 times more than L3. Now, if that is the reality, I mean, whom are we trying to fool here? So therefore, the government must realize that L1 is not the methodology. I think there has to be a most viable. I remember, of course, an instance where in one of the bids in the South American countries, one of the requirements, in fact, at the bidding stage itself was that the whole project and the details in the DPR is put on the regulator's website, and every stakeholder has a right to comment about it. Once that is done, then you precisely know who's the guy who has a house right in the middle of the project, and where do you need to remove it? Well, what's the risk involved in removing that? How it's going to be removed, and how the utilities underlying the whole place are going to be removed. So these are the key steps which only the governments can take. So far as the industry is concerned, industry level, of course, the CIDC, which is the Construction Industry Development Council, can take some leads in this, in really evolving methodologies wherein more collaborative methodology can be adopted for resolving dispute, at least at the downstream level where the government is not involved. And then, of course, construction industry itself, because construction industry itself is also managing large number of downstream contracts. That's where if they come out with a protocol, which is collaborative resolution of disputes through mediation and conciliation, that is something which can go a long way. But the fact remains that ultimately it's the government which is ultimately responsible for ensuring that the sector handles all projects with allocation of risk which is fair and proper. And I wish I could carry out an analysis. In fact, I was telling Sharad that we should be doing an analysis. What has been the cost of all these projects which have been rejected, the bids which have been rejected, vis-a-vis the bids which have been awarded?
I think that's definitely one for your to-do list, and we should regroup thereafter. I think we've spoken a lot about the challenges, and I'd quite like to get an opinion from our audience today. Having heard from all the panelists, I'm going to launch the second, well, we're going to launch the second poll now. Having heard from all the panelists, what in your opinion do you what do you consider to be the key barrier to collaborative working then? Do you think it's that projects are not being priced properly, the unrealistic programming David mentioned, lack of coordination and interface, or do you think there is another barrier? I would invite you to submit your choice now. Lack of coordination and interface. Other. Well, the other seems to have taken a good proportion. Please feel free to send through any details of what you think represents the other, because I'm sure we would love to have a separate discussion about them to try and thrash out those issues. But in the meanwhile, we can see that lack of coordination and interface is really the front runner. And that comes back to the think, do, doesn't it? And really managing that process and what it is that you need from your projects. And actually that takes me nicely now to the next part when we are thinking about the projects as they are happening and trying to manage that. Sharad, if I can come back to you, we can have that think, do at the outset. We can have the proper allocation of risk. We can have that conceptualizing of the project. But then when it comes to the project being in play, as it were, what do you think is the key then in terms of making sure that contract is not forgotten about and tucked away, that all that thinking is put into good practice? What do we need to bear in mind?
Okay, I think as far as efficient construction planning and management is concerned, I think I could put this in two separate buckets. One is having a good contract administration through an efficient contract administrator.
Mm-hmm.
And that's essential for the success of any project. The second thing is, and I think this is a no-brainer, it has to be efficient contract management. And that basically includes everything that David has talked about, everything that Martin has talked about, things that Atul has touched upon. So it's a very broad term, but an efficient contract administrator is essential because the project must be administered in a fair and transparent manner for both parties. Usually in Indian projects, this doesn't happen. The CA could even be an employee of the employer. And if that happens, then of course, one needs to have some sort of dispute adjudication or avoidance system that is not connected with the CA, because that would be a pure conflict of interest. But the CA then needs to be, he needs to have some discretionary powers as well. For example, in the awarding of interim extensions of time or cost, he needs to have those powers so that if the contract binds him, and obviously if he is bound to the contract such that the contract is going to fail, he needs to have the discretion to step away from that and take a decision as to whether he should assess the extension of time or cost or not. And as we all know, I mean, this is one of the most, one of the top 3 reasons of project disputes is the failure of the CA to, award extensions of time and costs in a timely manner. So he needs to have that discretion as well. Now, of course, when you talk about contract management, like I said, it's everything that we've talked about right now. The contractor has to have a very, very efficient contract management system in place that includes basically subcontractor management. It needs managing the employer, his expectations, a good quality system, good safety system, etc., etc. But it also includes good record keeping and good, for example, timely notices have to be given, compliances have to be done with, with tax laws, with employee benefits, and things like that. So apart from all this, one of the most important things that the contractor is expected to do is program management, and that's what David touched upon. And if that is not done properly, if you don't have a good program which is updated on a regular basis, when it comes time for claims, your claims are going to fall through simply because you are unable to show an entitlement for extension of time. And if you don't have adequate records, you're not going to be able to show what costs you are entitled to. So both those things are so important should you get into a claim situation. And this can only be done with a very, very efficient contract management system in place.
No, I agree with that. And I think actually if I can summarize all of that into one word, I think it's the fact that you have to be proactive, because it's having the system in place, but you've got to be proactive. You've got to control it and you've got to manage that. And the maintenance, well, having good record keeping system and maintenance of that, if there's anything that you take away from this hour, it is that. It's something that you don't need legal advisors for or experts. That is an internal infrastructure that can be very ably managed by clients, and that will have a huge impact. So wholly endorse that. Having thought about that, and you've mentioned sort of reacting to claim situations or delays, etc. That touches upon the next thing I wanted to talk about, is the way in which you react and deal with the unforeseen. Martin, if I could just come to you, in the way in which parties should approach the unforeseen. I think you touched earlier upon sort of the approach to contracts, putting in notices, not being defensive. But I think you're asking for a different attitude to dealing with challenges and problems that crop up. Could you just expand on that a little bit, please? And then, Mr. Sharma, I'm going to come to you to touch on it further.
Yes, sure. I think it's the issue obviously tends to reduce if you've had your collaboration at tender stage, and you've got the contractor involved perhaps and other parties involved. Therefore, the risks are reduced. But as we said, construction is a very uncertain process, and things will arise. And I think the key to that is making sure that when problems arise, they're notified quickly. As Sharon said, very often contractors see notices as simply a way to make a claim, and employers see notices as a way for the contractor to earn more money than is entitled to. And therefore, immediately you have an us versus them, you had an adversarial point. What one should see is that notices are there for a reason. They're there to give notice of a problem. And if that problem is dealt with collaboratively at an early stage, that problem may well disappear completely. Or if it doesn't disappear, its effect on the contract, on the project can be mitigated dramatically. So one needs to look at that process of notification as a positive process to assist the benefit of the project itself, rather than either of the two individuals. It's looking at a government project, looking at making sure that's delivered on time, on budget. If you have those notices and they're dealt with, problems will be capable of being resolved, and they won't, because if they don't, contractors tend sometimes to keep these things to themselves, and they raise them at the most inappropriate time where most pressure is put upon the employer, and therefore disputes arise. The dispute avoidance mechanism doesn't work, the resolution mechanism doesn't work, and people like you and me, Rupert, earn a lot of money at the expense of the public. We must avoid that.
I'm smiling knowingly at you, at all those pitfalls that you talked about, less about the earning lots of money, but definitely I hear you. It comes back to that bit about being proactive and positive. That's what we're really trying to drive. And I think that is absolutely key, because harnessed early on with that outcome of sort of a successful project lodged firmly in everybody's minds means, you're going to get there quicker, and with everybody feeling happier. We'll now come to the elephant in the room, which is effectively the pandemic and the impact that has had, because we've talked about unforeseen and the impact of that. I mean, Mr. Sharma, Martin's highlighted an approach to dealing with problems and notices, but the last year and a half has brought something that we could never have anticipated, and I'm sure that has been, you've seen that reference to force majeure provisions in contracts, and that being a mechanism to deal with the unforeseen. Can you please give us a bit of information about your experience with how you have managed the impact of the pandemic and approach to force majeure provisions in Indian contracts?
Yeah, you see what happened, Rupa, when the first lockdown happened, there was complete uncertainty and mayhem. People started, running to the courts to stop the bonds from being called upon, and everybody thought that, because nobody had experienced this level of a force majeure event, or this kind of a force majeure event. And of course, whatever force majeure the industry had experienced was intermittent and maybe, some earthquake or things like that. But this was something which was completely new to the whole industry. And actually, people didn't know whether it is going to arise out of the contract, or is the law going to provide you some solace in terms of extension of time, in terms of money? The government did come out with notifications in public projects where they extended the time for completion. And people, when went to the court, of course, the conclusion was that it's a function of the contract, not the law. So, therefore, the key lesson that we need to learn here is that when you're drafting your contract, you should be very, very clear as to what is force majeure. But of course, the problem arose that what is the consequence of force majeure for the contractors? Obviously, if it is a function of the contract and if it is covered by the contract as a force majeure, even then, the question arises as to whether you are entitled to extension of time or money as well. But then there was a new dimension which came in. Of course, we started advising clients that, it's not purely force majeure, because the lockdown, the pandemic per se could have been a force majeure even under the contract. But so far as the lockdown was concerned, the lockdown was as a consequence of the notifications issued under the Disaster Management Act. And when that happened, of course, the jury is still out, and I must not jump the gun by coming to a conclusion here. But large number of employers, a contractor started making claims with regard to change in law. And there, of course, you can be in money as well. So, as I said, the jury is still out, and we are still not sure as to what kind of interpretation is going to come in. But I think this is something which has, again, as I said, has brought in a lot of collaborative approach within the community of contractors and employers. Well, of course, government being government, nobody will take a decision. That's where the problem rises in terms of, it goes into a dispute, and nobody will take a decision. So therefore, what is the key here is a troubleshooting mechanism through a statutory mandate, which needs to be going out to the industry as such from the government or the legislature, whether it's from the form of a notification under a statute, or it's in the form of an ordinance or an act. So ultimately, this situation will have to be dealt with at a level where everybody understands the problem, and as we go back to more collaborative, more mediative approach and more conciliatory approach, rather than fighting against each other, because that ultimately is not going to help the industry at all.
No, I totally agree with that. And as you said, the jury is still out on a number of those issues because it is so unprecedented. The key shift then now is that, having had something so unforeseen take place, when we are now looking at the drafting of contracts going forward, we can't take the same approach. Sharad, if I can come to you, in looking forward now at the negotiation of new contracts, how has the impact of what we've experienced over the last year, how has that influenced the way in which parties are negotiating contracts now going forward?
Rupa, I think part of this question has already been answered by Atul, because the position that the parties will assume will depend a lot on the outcome of what is going on now in courts. A lot of positions have been taken. When the lockdown was first imposed, it took everyone by surprise, what happened, the effect, the labor movement, and it was on such a large scale that nobody could do much about that. Which is why, as Atul mentioned, the government came out with a notification extending, support by way of extension of time from 3 to 6 months, depending upon the project and the situation. Of course, they didn't give any guidance on that, but they did put a proviso, and that was that that the notification would be effective, from the date of 20th of Feb, but for parties that were already in default as of the 19th of Feb, they would not be entitled to such an extension of time. And that was simply just inviting disputes, because, they didn't specify what sort of default parties could be in. Was it concerning quality issues? Was it concerning X, Y, or Z? And not just delay issues. Secondly, a lot of employers took that to mean that they could actually call a default on contractors who were applying for extension of time. Instead of awarding extension of time, simply terminate the project, citing the default. So that has caused a lot of litigation in turn, and we're dealing with a couple of those now, even where force majeure clauses specifically allowed force majeure extensions of time if a party were in default at that time and was in the process of curing a default. So a lot of this position will solidify going forward. The second wave has, of course, I mean, it's not a force majeure situation. So, it's not a situation that has been forced on the contractors. This is something that they can try and mitigate. And a lot of contractors have been able to mitigate the effects of the second lockdown, simply because it wasn't a very extensive lockdown. And we had the prior experience of the first lockdown. But like I said, the negotiating positions of the parties going forward, especially with critical clauses that Atul mentioned, that we are now using, to assist parties, like change in law, being a part of the relief measures, etc. These will, I think, gain prominence depending upon how the courts, how the arbitrators and the appeals courts look at this issue. So I think going forward, we'll have more clarity on this.
Thank you. I'm just conscious on time, but I do want to just come back to David then. Negotiating position going forward from a legal perspective is yet to be determined. But David, if we go back almost to the beginning when you're saying, look, you've really got to think about how you program and plan this project. The impact of the pandemic, it requires a change in approach as to how you program and plan your project. Have you got any final tips that you can advocate as to how that might be approached, having experienced what we have done as a result of the pandemic and the impact on workforce, resources, etc.?
Yeah, so this is a really interesting area for me, but I'm conscious we're running out of time. Again, when we're planning and programming, looking through the kind of pandemic period, studies have suggested that the resources were hitting about 70% productivity because of all the implications of COVID with social distancing, logistics on site, supply chain problems, resource problems. So my question really is, now that we're bidding for work with all of those things known, are we taking them into account in our new programs? Have contractors said, well, actually, this job's now going to take us 20 to 40% longer because of all these issues that we're now considering? Or are we going all the way back to the beginning when things aren't, no one's actually taking account of how these things should be programmed and planned out? And then we run into the same, cyclical issues that we always do. But it would be really interesting to see how contractors are bidding for work. Now we know it's, as we said, it's not force majeure, it's known.
But I think that's the interesting thing. A developer's got to have confidence in the contractor. And I think we all accept that. So given that the developer is also going to be alive to these risks from happening, are you going to look more favourably at a contractor who can demonstrate that they've thought about all of these risks, planned for them in terms of resource and programming, and address that up front? I would have thought, even if then that means that potentially the cost looks slightly higher than the next contractor and it's going to take a bit longer, you can have more confidence in the chance of success and it adhering to that plan. So what I would advocate is to take on your approach, David, and plan for that, and it will wholeheartedly be supported by those developer clients. So that's probably my message, which now, having planted that seed, I'm going to go to my final poll question for the audience and say, given what we've all discussed and the likely outlook for the industry, which do you think represents what we are facing? A new dawn for the industry, wo subha kabhi to aayegi, default to old habits, kabhi khushi kabhi gham, or winner will take it all, Jo Jeeta Wohi Sikandar. If I can ask you to put forward your submission, please. Love it. Over 50%. Optimists. Fantastic. That's exactly what we needed to see. We're either dealing with optimists or we've convinced them. But I think, you know, stating the obvious, a lot of what we are saying does come down to common sense, improvement of individual behaviours, which can go a long way to make a big impact. So hopefully that's what we will start to see a bit more of. Looking at the Q&A box, there's one, I think, for Mr. Sharma that's come through, which I think you may have covered, but if you want to add any further comment. The observation is that the pandemic has brought multiple claims and disputes on force majeure events. In most of the government contracts in India, the pandemic, epidemic, and continued effect of the same are defined as force majeure events. The contractor are not entitled for any claims, and most of the contractors are suffering from severe cash restrictions. What do you think are the options for the contractor? Well, the next question is, what should be the future plan, and how do you think this can be addressed in future contracts, which I think Sharad has touched upon. But Mr. Sharma, did you have any final comments on that?
No, I think obviously the problem lies in the fact that it is going to be it is covered, as the questionnaire asked me, in the definition of force majeure, and you are not entitled to any costs. Well, as I said, because the lockdowns are something which is though linked to pandemic, but essentially is a government action, and therefore it could be covered in change in law. And moving forward, as Sharad has already answered, we need to be very clear in our contracts as to what is the outcome of a situation like this. And I believe that there needs to be some sort of a troubleshooting mechanism for dealing with contingencies like this.
Okay, thank you very much. There are no further questions. Thank you, a massive thank you to all my panelists, but also a massive thank you to everybody dialing in and for your observations as to the way forward. If you do have any further questions, comments or queries, please feel free to send them through to myself or to any of the panelists directly. Thank you very much and have a good day.
Thank you.
Thank you.